All right, we'll call the next case this morning, Bombardier Aerospace versus Signature Flight Support. I want to give us just a minute to let everybody get settled in. Counsel, you may proceed.
Good morning, Your Honors. May it please the Court. My name is John Hoff, and together with Al Musinski, we represent the appellant, which is the former plaintiff, Bombardier Aerospace Corporation. This is an interesting case, quite unlike the last one you heard, a civil matter arising out of damage to 6 aircraft by Signature Aircraft.
Mr. Hoff?
Yes, sir.
We've got a lot of ground to cover, and we don't have a whole lot of time. I'll stop your clock here for just a minute,
yes,
because I forgot to tell you, since we have a cross appeal, or I guess it's really a consolidated appeal, we're going to let you argue your main appeal. We'll let Signature respond to your main appeal and make their case on their separate appeal, and then you can come in and both respond to them and rebut what they say, and then they'll get the last word. So we'll kind of go back.
20 minutes in total, though, for all of just
Yes.
that, all those combined aspects.
Right.
Yes, sir.
Mm-hmm.
Okay. Well,
So let me tell you the 2 areas. I mean, there's a whole lot of things that we could talk about in this case, but there's 2 areas, and I'll be the first to confess that I barely understand Florida law, let alone Texas or New Jersey. That being said, we've got to do something with the case. There are 2 areas that really have me confused, and one is this idea of a reasonable demand and the jury instruction that's given to the jury, and whether your demand, and so that's one issue. And the other issue, I guess, more relates to the statute of limitations, which is what's the breach, when did it occur, when did the clock start running? I mean, to me, those are the 2 issues that I've really got to get my head around.
I agree.
And I'm going to be talking to opposing counsel about those as well. And that doesn't mean that I want to minimize anything else in the case, but to me, those are the ones that cause me the most heartburn in trying to get my head around the law and the facts. I think the facts are probably a bit more clear than the law is. So help me, and take them up in either order that you want to, but help me understand those 2 issues from your perspective.
Yes, sir. Well, to the first issue, and that is this reasonable demand business, there's no requirement as an element of breach of contract under Texas law, which everybody concedes was the choice of law. There was a contract between Signature and our client.
We understand the Texas law.
So there's no question that Texas law is what we're thinking about in terms of its requirements. There is no requirement.
Is your position that if you made an unreasonable demand, you ask for $5 million and the jury gives you $1,000, that only goes to the issue of attorney's fees under the Texas statute?
Yes, sir.
And it doesn't diminish whatever contractual damage you claim? And what's your best argument, your best case for that proposition?
Well, best case is by starting out making a high request, it works.
No. My question is, cite me your case. Give me a Texas case that you think, or a Texas statute, the one that you think if I was going to build my house on, that's the foundation for that argument, that if you make, let's just assume for my question that you make what everyone concedes is an unreasonable demand as to the amount, that your only penalty for that is that you lose your ability to seek fees, that it does not affect your underlying damage claim.
Well, there were over 200 cases cited, as I'm sure you guys were.
I know. That's why I'm looking for your best 1 or 2.
I'll do my best to try to find it.
Maybe you can do it.
If you need a minute to do it on rebuttal, you can. But
okay, that probably is best. Otherwise, I got this many cases
okay,
to go through to find one.
But your argument essentially, if I synthesized your brief down correctly on that point, your argument is, even if my demand was wholly unreasonable, and I agree you don't concede that, but even if it was, the penalty is I lose or my client loses the right to fees.
Everything.
Not the underlying damages.
Yes, sir, yeah.
Okay.
And we had agreed in this case that the issue of attorney's fees were bifurcated. They weren't even in the case in chief. That was not to be decided.
Well, I understand they
going in.
take a completely different view. So how do you think when the jury instruction is, ask the jury to determine whether the demand was reasonable,
Yeah.
did the trial court give the jury any guidance as to whether that demand went to the time that the demand was made, the reasonableness of when the demand was made, or did that go to the issue of the amount of the demand?
It went to, my recollection was it went to the amount of the demand, and if the jury found that the initial amount was unreasonable, then they need to consider nothing further, and it worked as a forfeiture. They can go right on to the next count, and they did that 6 times.
That's what happened.
That's exactly what happened 6 times. So apparently if you make and of course then that violated the Florida procedural law, the evidentiary law of offers of settlement, offers of compromise. It should never have gone to a jury.
Okay, well, like I say, I understand that that's an issue that you want to talk about, but I want to try to focus on these two. Let me just, let me go now to the other issue that, and then I'll try to be quiet and let you argue a case a little bit. The other issue is I'm trying to understand Texas law as it relates to a breach of contract. You know, there are potentially 3 claims that are arguably untimely depending on how that's interpreted. And, you know, Texas law seems to be somewhat consistent that, you know, the breach occurs when you have a legally cognizable injury.
Yes, sir.
So when I went back and I looked at your complaint has 2 separate paragraphs, and it's pretty much identical in each count. And it says claims 2 breaches. Breach number 1 is you damaged my airplane. Breach number 2 is you failed to pay for those damages. So if we assume that they damaged your airplane and they were at fault, and again, for the sake of my question, just assume they messed up your airplane and they were at fault and they had an obligation under the contract to handle your airplane with reasonable care. Why isn't that the breach? Your whole argument seems to be based upon this is not an agreement to take care of airplanes, this is an agreement to pay if you damage the airplanes.
It was foreseeable that a damage could occur. That was contemplated by the parties and built into the contract.
So help me understand this whole concept of an agreement to pay. What, under Texas law, what is an agreement to pay? I mean, to me, the basis of this contract at its core was you provide airplanes to customers who fly them all around the country, and they clean, fuel, tow, and store those airplanes.
Exactly, yes.
I mean, everybody understood that there's some possibility that they could mess up your airplane, and they said, if we do, we'll pay for it. But the main focus of this contract was you want to have airplanes where your customers want them, in good condition, and they provide ground services.
Correct, yes.
So why isn't the breach of the contract here when they bollocks up your airplane, as opposed to not paying for that damage?
Because the balancing of the airplane would be a tort. That was when the damage was incurred. It isn't the damage that was the breach.
Well, no. I mean, Texas, I'll admit, Texas has this odd idea that you can negligently breach a contract.
Yeah.
But I think you would agree with me that if it's not an express provision, it's certainly an implied provision in this contract, that they're going to handle your airplanes with appropriate care. I mean, you don't expect them to go out there and treat them like drunken sailors. I mean, these are expensive airplanes, and you want them to be treated appropriately. And presumably, you thought they could do that, or you wouldn't have contracted with them. So, I mean, they might also be torts under contract law, but I think Texas law says that if the essence of the contract, if what's damaged is the property that's the subject of it, then it's really, no matter how you phrase it, it's a breach of contract.
Well,
So, I mean, I'm willing to accept your argument that this is a breach of contract claim and not a tort, but I'm still not there on the idea that the breach didn't occur when the damage occurred.
Well, at the risk of oversimplification, you can't you can't squeeze an orange and get apple juice, and you can't squeeze a tort, or you can't squeeze a contract and get a tort remedy. When you have a contract, a tort, and when I teach this stuff, I use a donut and a donut hole. At the risk of oversimplification, I put a big K in the middle of the donut hole, and that's a contract. And a tort is a residual category of, if I remember Black's Law Dictionary, any wrongful, harmful, or offensive action arising not out of contract. So if it arises out of a contractual relationship, the contractual relationship dictates the relationship of the parties. So you can't, well, I'll waive the contract, I'll sue and tort. You don't have that option. If the relationship arises in contract, then the contract deals with all aspects of it, and the contract contemplated that there would be what in the business is called ramp rash, minor damage, little dings, things happen, and when that happened, they would be presented with bills, and there'd be some negotiating process, and it would be reconciled with them having a contractual duty to pay. The breach of the contract wasn't the ramp rash or the damage, the dings, as you put it. The breach of the contract was the failure to pay.
You pled that it was. I mean, you pled in each of your complaints, you alleged 2 breaches, separate paragraphs. Breach 1 was they messed up our airplane.
Yeah.
And breach 2 was they didn't pay for the damage.
What I was trying to articulate in that was, if they didn't ding the airplanes, it wouldn't, the duty to pay for the damages that hadn't occurred wouldn't arise.
I mean, I don't have a problem with the idea that if they messed up your airplane, they're contractually obligated to fix it.
Well, the issue is, when did the accrual occur? When did the action?
Could you have sued them if they they banged up your airplane they banged it up today?
Yes, sir.
Okay. Could you have turned around and sued them right then?
No, sir, because the contract said that they would have a reasonable opportunity to fix and pay for the damage that they caused. That was built into the contract. So a cause of action...
Where does it, I mean, I'm not asking this as a hypothetical. I mean, I'm asking you honestly. I saw the provision, I think it's 4B or 4F.
4F, yes, sir. Yeah.
That says, if we mess up your airplane, we'll pay for the direct damages and up to $200,000 in indirect, consequential damages. I didn't see anything in there that says that, we'll fix your airplane or make it right, and there's no time limit in the contract. It just says,
we will pay for the damage.
Here's the services you're supposed to provide, and, if you mess up the airplane, you pay.
You understand it perfectly. So until they refuse to pay, until you had an unequivocal refusal to pay, go away, we're not going to give you a dime. Until that happens, I don't think we have a cause of action that is really accrued, because you have half the problem, the damage has occurred, but then there was this reasonable adjustment period. They had an adjuster, McBreen, that kept saying, oh, don't worry about it.
But that's not in the contract anywhere. It doesn't say anything about that. It just says they'll pay. So, I mean, my question is, as a pure matter of law, could you have sued them the day after they damaged these airplanes?
I don't believe we could, because I think they would be allowed, under the terms of the contract, a reasonable amount of time to figure out what the damage, the extent of the damage, and they ding the aircraft. 20 minutes later, you don't know what the damage was. It required structural engineering. It required tear down, determine what it was. Until we had liquidated damages to present to them, I don't think they had a duty to pay until there was some reasonable indication of what the damage, the extent of the damage was.
You had some duty to give them notice, whether reasonable or not, is that correct?
Yes, sir, yeah.
Was that strictly a result of the contract, or is there something about Texas law that required notice as well?
No, it's just a function of the contract. Of course, they had notice because they were in sole care, custody, control of aircraft. The reason we knew our airplane was damaged because it happened on their watch while it was in their care, custody, control. So they had notice of the damage because they're the ones that caused it.
There's no contractual provision. I mean, I've seen a lot of contracts that say, if I think I've got a claim against you, I've got to give you 30 days notice before I can sue you, or I've got to present the bills to you and give you, there's nothing like that in this contract.
You're right.
Do you have to be reasonable as to the time of your notice?
Well, I think, some kind of a laches argument would be, if you wait and you never ask them or make a presentment to pay, then I don't think they have a duty to pay until there's been a presentment of some sort, or a request or a demand.
Do you, in essence, have the ability then to, for example, double the statute of limitations? If it's a 5-year statute of limitations, can you wait till 4 years and 364 days, give notice, and then the statute starts to run and you get another 5 years?
No, I wouldn't view it that way. I would view it that the statute of limitation accrues, and there's a pretty good Texas case, this ambulatory infusion therapy case, says that when you have an unequivocal act of refusal, that the breach of contract claim arises when the contract is breached. The contract is not breached until the wrongful act occurs, and the wrongful act is the failure to pay, not the incursion of the damage. That was contemplated in the contract. What was not contemplated is that they wouldn't refuse, and they would stonewall you and then refuse to make any payment.
Well, no, okay, but if you wait 4 years to give them the notice, it's your position that the cause of action has not yet accrued, right? Until the notice.
Well, not until the notice, not until there's a refusal to pay.
Well, notice plus a refusal to
Yes, sir.
pay. So
Yes, exactly.
you wait 4 years to give them the notice, then plus some time thereafter, that's when this cause of action accrues.
Yes, sir.
So now you get another 5 years, assuming it was a 5-year statute.
Not another 5 years, that's when you get the 5 years, that's when the action accrues.
But it would give you, in essence, it could give you 10 years from the date of the injury.
Yeah, in theory, I would agree with you, yes, sir, yeah. So,
You're down to 5 minutes if you'd like to hold on to it.
yes, sir, I'll do that then. Okay, well, really quickly, the attorney fees aspect of it, we just feel that this was a bifurcated case, and the evidence of the prejudicial evidence of the offer of settlement went to whether we should get attorney's fees or not, which was agreed to be bifurcated going into the trial. So there was a tremendous amount of prejudicial information, and there were 11 errors. I think we've gotten to 2 so far, so the rest of it is all in the briefs, and I guess you have a pretty good idea of that. So let me reserve the rest of the time. Thank you.
Morning, sir.
May it please the court, John Murray for Signature Flight Support Corporation. Judge Orfinger, I believe you really put your finger on the problems that exist in this case. And I think that Judge Munyon actually very well addressed this issue when she did her order on the motion, the post-trial motions. And she said at that time that there is no authority provided to support the position that a creditor could demand what was clearly not due under the contract and manufacture a breach of contract cause of action.
Well, if breach of contract, I mean, would you concede that if there's not an express provision, there's certainly an implied provision that when you're servicing their airplanes and doing things that, you know, you're not supposed to run into them with power carts and drive away from them with cords hooked up. I mean, we all agree that.
Of course.
And that the contract contemplates that if that happens, that you'll pay the reasonable damages. So your suggestion is that under Texas law, if you did $10,000 damage to an airplane and they make a demand on you for $1 million and a jury comes back and ultimately says it was $10,000, that you shouldn't have to pay the $10,000 because they were so unreasonable in their demand?
No, I don't think, that's not what I'm saying, Your Honor. And the evidence in this case is such that with respect to every one of these incidents, there was demand, there was response, there was dialogue between both parties to this case about the damage that was done. There's no question about that. The testimony from the signature people, Ms. Kehoe, was that she was on a phone conference with the Bombardier risk manager and said, what are we going to do about these claims? And she said, forget it, I've hired a lawyer, we're going to, I don't want to talk to you about it. So the groundwork was set in this case.
Let's just focus on the law. My hypothetical question is purely this. You and I have a contract.
Yes.
You breach by damaging my property. I make a wholly unreasonable demand. I want $1 million for this $10,000 problem. And you say, look, I'm not paying you $1 million. And you say, it's either $1 million or we're going to court.
Correct.
And so we go to court. Jury comes back and says $10,000. So is it your position that under that hypothetical, because my demand was universally recognized as unreasonable in amount, that you now get away scot-free for the damage that you concede that you did?
Yeah, I think I think Judge Munyon addressed.
Well, I
that
understand
issue
that was
well.
Judge Munyon's theory. You argued it and she bought it. Help me understand, what is your best case that supports that theory of forfeiture?
Okay, no, the thing that I'm not talking about the reasonableness. I'm talking about when Judge Munyon said that plaintiff argues that the defendant should not be permitted to damage its aircraft and fail to pay that damage. That's what you're saying now. And she continues by saying that argument would be very persuasive in a tort action. However, the plaintiff chose to proceed in contract.
Why is it?
That's
But my
line.
question is, why is it any different? If you breach the contract by damaging my property, I make a wholly unreasonable demand. Why do you get away scot-free? What case in Texas, give me any case in Texas that supports that concept of complete forfeiture because I make an unreasonable demand? I understand I may not get my attorney's fees under the statute.
Right.
Texas has this concept of excessive demand and all that relates to a forfeiture of attorney's fees.
Judge, it's hard not to bring in some sort of reciprocity or equitable issues here.
I'm asking you to give me a case, give me something I can go back and read from Texas. And trust me, I have spent a lot of time reading Texas law over the last few weeks that says if I make an unreasonable demand, an unreasonable as to amount, because the jury instruction didn't give the jury, in my mind, any guidance at all, whether it was an unreasonable amount as to when it was made or the amount of how much it was made for, although your argument, I read your closing argument, your argument was clearly they made an unreasonable amount demand.
Yes.
They asked for way, way too much money.
They did.
And that was your theory, so give me a case that tells me that that theory is recognized in Texas law.
I don't think there are any cases that specifically say that in Texas. We drew in our brief an analogy between indemnity contracts where there is a reasonableness requirement.
Okay, but this isn't an indemnity contract. This is a straight contractual damages contract. You had a duty expressly implied to handle their property with reasonable care,
We
which
did.
presumably means not driving carts into it, not, doing the other things. I mean, these
did.
things happen, and so there's no Texas case that you can point to that says in a direct contractual relationship, perhaps outside the indemnity field, that if a contracting party makes a wholly unreasonable demand, but they have legitimate damages. I mean, you don't dispute that, you may dispute whether you caused them or not, but you don't dispute that some of these airplanes were legitimately damaged and that your client was probably on the hook.
No disagreement with that, Your Honor.
But your idea is that they forfeited it because they asked for too much.
Well, not simply because they asked for too much. They clearly did, and the jury found that consistently in each of these 6 claims. But the basis of their making this demand was in order to remove this from the tort arena and place it into the contract arena. It was, as Judge Munyon said, a manufactured contract case. That's the sole reason they did that. They made the demand, and according to the testimony at trial, refused to reasonably negotiate that demand.
It would make a difference whether it's a tort or a breach of contract as to whether there's a forfeiture because of an unreasonable demand.
Well, if it's...
If your client damaged a plane, they brought the action within 2 years, and they brought it as a tort, and they said, this cost us $1 million worth of damage, and you said no, it was $10,000, and you were wrong, it was $10,000, why wouldn't you be obligated to pay the $10,000 whether it's a tort or a contract? I mean, as far as the reasonable demand requirement, you said, well, they try to manufacture a breach of contract action from a tort. I'm asking you, does it make a difference if they brought a tort action or breach of contract action, why would there be a forfeiture if their demand amount was unreasonable?
Under either tort theory or contract theory, there's no requirement for a demand at all in either of those two. If they thought we damaged it tortiously, they would sue us in tort. If they thought we damaged it by breaching the contract, they would sue us in contract.
So they didn't have to give you a demand at all in this case?
No, sir, not under Exhibit 1, which is the FBO agreement.
So if they had no obligation to give you a demand at all, how does giving an unreasonable demand somehow reduce their rights?
Because this is the fly in the ointment in this case, Judge, because they have manufactured this extension of the statute of limitations. They're urging the Intermedics case, which says, irrespective of when when a contract action, when the damage occurred, the statute doesn't begin to run until there is a demand and a rejection of that demand.
Okay, but your argument about a reasonable demand, is it limited only to the statute of limitations issue?
That was the only, the demand was the focal point of this case. That was what this case was about.
If the demand was unreasonable, but they had sued you within the appropriate amount of time they could recover?
Then the demand would not have been, no, I don't think they could have recovered the damages they were seeking, no. But they would not have been able to.
They wouldn't have forfeited by virtue of an unreasonable demand. Your position is the only relevance of the unreasonable demand is the way it affects the statute of limitations.
I'm saying that they came forward. It's not.
Does it matter whether the demand was reasonable or unreasonable? Your position is the statute accrued on the day that the injury occurred, the damage to the plane occurred, right?
Absolutely, absolutely.
So what difference does it make whether the demand was reasonable or unreasonable?
It makes a difference because they have used that as a device to extend the statute of limitations.
Okay, but can they use a reasonable demand to extend the statute of limitations?
No.
And they can't use an unreasonable demand to extend the statute of
No,
limitations?
I don't think they
So what is
can.
the relevance of whether or not the demand is reasonable?
I think that whether the demand is reasonable or not goes to the nature of the claim, the way that they overreached. They wanted the demand. They claimed that the breach on our part was failure to pay what they demanded from us. And we simply showed to the jury that we didn't do that. We didn't fail to pay a reasonable demand in this case. And that was replete in the testimony by their own witnesses.
But if it had been reasonable, your position would have been it didn't make any difference. The statute of limitations had expired anyway, right?
The statute of limitations in our position, Your Honor, has expired on all 6 of these incidents.
And the reasonableness or unreasonableness of the demand has nothing to do with that.
Not with the expiration of the statute of limitations.
What does it I still don't understand what it has anything to do with then.
The reasonableness?
Yes.
Because they're here because they took the position that until Mr. Hoff made a demand on me by letter, and there was a putative rejection of that demand, that this cause of action didn't even accrue.
And the trial judge agreed with that if the demand had been reasonable?
No, the trial judge, Judge Loughton had this case initially, and he ruled, the summary judgments were back and forth quite vigorously on that particular issue. He ruled, then Judge Munyon inherited the case, and she stuck with that ruling. So they were in court on all of the, not all of them because they dismissed a number of them, but the contract claims that they made. And that's the way it went to the jury. And our position was simply that, you know, if you're going to use that as a device to stay in court, if you're going to use that as a device to get to the jury, then you've got to let the jury know what's going on both sides of this case. That is, they're demanding way excessive amounts, and they're saying that our failure to pay those way excessive amounts enables them to maintain a lawsuit against us.
Well, let me ask you this. You say all 6 counts were barred by the statute.
sorry?
You say all 6 counts were barred by the statute of limitations?
Yes, Your Honor.
But that's only if you assume the 2-year statute of limitations for tort supply, correct?
That's correct.
I mean, if you apply a 4-year statute for breach of contract, even if you started at the day of the damage, that would only bar 3 counts out of 6, right?
That's correct, Your Honor.
But this jury instruction was given as to all 6 counts, right?
That's correct.
Well, the court only instructed the jury on the breach of contract count.
Correct. That's all this case was about, was contract. We went in on a motion to dismiss.
Okay, then how could it have been proper to give that instruction at least as to 3 counts? Because you just told Judge Poirier that reasonable argument, was part of your statute of limitations argument. But your statute of limitations argument didn't apply to 3 of the 6 counts. So how would that instruction have been proper as to those other 3 counts?
The statute of limitations argument didn't apply to 3 of the 6 counts.
As far as the breach of contract.
They did apply, Your Honor, to all 6 counts, because we were in on all 6 counts.
But three of the incidents occurred within 4 years of the lawsuit being filed, correct?
Correct. And 3 occurred outside of a 4-year
Right.
period.
So as to those 3, as far as the breach of contract, even if you accept your argument that you start the clock at the day of the incident, the statute of limitations would not bar those 3 counts.
That's correct, but that's not the posture of the case as it was submitted to the jury.
Well, the judge only instructed him on breach of contract. The judge didn't instruct him on any tort counts, right?
That's correct.
In fact, you opposed an amendment, when they sought to add a negligence count. You opposed it.
After all the evidence was in, yes.
Right. Frankly, I don't think the trial judge abused the discretion there. But the point is, that just is further confirmation that this case was submitted to the jury on a contract
Yes,
and not a tort.
yes.
So for 3 of the 6 counts, the statute of limitations was not an issue.
It was an issue, Your Honor, because those contract cases were submitted to the jury. And our argument was that making the demand and having a rejection of that demand did not accrue a cause of action so that the statute of limitations was extended.
Well, I think the point, though, is on the 3 counts that occurred within 4 years of when the lawsuit was filed. If these were properly contract claims, and that's if, I'm not asking you to concede it, though it would make my life easier. But if those were properly contract claims, then you agree that they would be timely. Those 3.
The last 3.
Yeah,
yes.
the most recent of the 3.
They were filed within 4 years, next preceding, they occurred within 4 years, next preceding the filing of the complaint, yes.
Okay.
And therefore, the other side would not forfeit their right to collect on those 3 by an unreasonable demand, would they?
Your Honor, I think that they would forfeit their demand because...
But I thought you told me the unreasonable demand was only relevant if there was a statute of limitations problem. If the day after the incident they had sent you an unreasonable demand and the next day they had filed the lawsuit against you, you couldn't say you have forfeited your rights from the claim 2 days ago because you gave us an unreasonable demand, right?
No, Your Honor, could not. Because, as I said earlier, irrespective of whether a case is brought in tort or contract, within a period within the statute of limitations, they put us on demand.
So
Demand at all.
as to the 3 latest claims that were not barred by the statute of limitations, they did not forfeit their right to collect those damages by virtue of an unreasonable demand, right?
That's very difficult, Judge, having sat through 2 weeks of trial of this case to see the way that these cases were presented. And I think that since they used that as the pivotal point in this case...
But the jury was allowed to require them to forfeit timely filed claims because of an unreasonable notice, right?
They were. Unreasonable demand.
And your position is that an unreasonable demand does not require you to forfeit your damages on timely filed claims, right?
I'm saying that they filed the contract claims within a 4-year period of time, or if they had filed tort claims within a 2-year period of time.
Wasn't it error for the trial judge to let the jury consider all 6 counts on the basis of an unreasonable demand rather than only the 3 that had not been filed within 4 years?
I don't see how it could be, Judge, because anytime there's a contract, reasonableness is implied. That's black letter law that I learned in my first semester in law school.
But there was no obligation to file any demand at all, you said?
None if they're done within the statute.
So they don't have to file one, but if they file one and it's unreasonable, they forfeit all their rights under the contract?
I think that under the circumstances of this case, they did. Not
What are the circumstances of this case that makes it different from other cases?
Well, they, for example, were extremely unreasonable. One of the demands that they
Oh,
made
so
is...
if you make an extremely unreasonable demand,
No.
you can forfeit your rights under the contract?
No, but I think you have to look at this case in its full context.
What if they had only sued you on the last 3 claims? Would we even be here arguing about reasonable demand?
I don't know that we would, Your Honor, because that...
So why did they lose their rights because they happened to incorporate it with the earlier 3 demands rather than filing it as a separate lawsuit?
As I said, I think it's necessary to see the case in its context and to see the way that the claims were presented and the way that the dealings went, where there was refusal to negotiate on any of these claims individually. There was a demand in one case for $1,300.
They don't have a duty to negotiate on any of the claims, right? They could just sue you. They don't have to negotiate at all under your theory, right?
They could have just sued me, but they would have sued me for $1,300 for damage to the airplane instead of $1,300 plus $150,000 attorney's fees for that one claim. And it was the unreasonable nature of the presentation of this demand, including the last 3 that were timely within the contract statute of limitations, that swayed the jury to come to what we think is the right decision in this case.
Counsel, you've got only about a minute left. I'll give you an extra couple of minutes, and I'll do the same for Mr. Hoff, because I know I'm guessing that you're having enough fun that you'd like to talk about your separate appeal.
Yeah, I wouldn't miss that opportunity, Jeff.
It was worth the trip over, wasn't it? So I'll give you a total of 3 minutes, and you can, I've stopped it while I'm telling you this, if you want to talk about your cross appeal, if you want to save this for, I guess there's nothing, but if you don't talk about your cross appeal, then you're not going to get to rebut, because they don't get to talk about it either, I suppose, but, you know, I'll let you use your 3 minutes however you want.
Well, I think the cross appeal, we can simply rely on the briefs if they're not going to...
Okay, so you want to save your 3 minutes, well, if you don't want to talk about the cross appeal, then you're not going to get any more time, so...
That'll be done.
You'd be done. So if you want to, I'll give you another 3 minutes to keep on going, if you want to keep on going.
Okay, I think I will defer that, Your Honor, and, because you said that Mr. Hoff would not be able to address the cross appeal then?
Yeah, if you're not going to talk about the cross appeal, then you're not going to, get to come back up, and he's going to get to talk about his main appeal, and then we're done.
That's fine, thank you.
Okay. Thank you so much, sir.
Thank you.
Well, I think you all have gone to some nitty-gritty issues here. If they'd made a tender of any amount, then I think their argument would be a little less disingenuous, but they never came back with anything. So if somebody makes an offer, that whole settlement negotiation process is what Florida Evidentiary Code is designed to prevent the jury from being prejudiced about. So
Did you have any obligation under the contract to make a demand?
No, sir. That was not a requirement.
If you had no obligation to make a demand under the contract, then why couldn't you just have sued them the day after the damage occurred?
Because in the contract, they said they had a duty to pay, so impliedly, there were our airplanes, we got to fix our airplanes. They didn't have an obligation to fix our airplanes, we fixed our own airplanes. It implies that there had to be some kind of a presentment of liquidated damages. Here's the paid receipts, and this business about the attorney's fees, what we said was, if you don't come to the table and deal with us, under the terms of the contract, you may have to pay up to $150,000 of attorney's fees, which I assure you, this case is already blown through.
Well, let me ask you this. If you have a 4-year statute of limitations on a breach of contract.
Yes, sir.
And there's a damage, and after 3 years and 364 days, you make your demand, a demand that you're not required to make, is it your position that's when the 4 years begins to run?
No, our position is that we were lulled into this, the intermedics case about all this.
But under your argument, why wouldn't it begin to run then?
Because they'd have to have some reasonable amount of time to pay the damage.
Let's say 3 years and 11 months, you made the demand and said pay within 20 days.
I think there's some implied reasonableness on both sides. We would have a reasonable amount of time.
All right, so you could say 3 years later, you said pay within 6 months.
I don't think we could park the airplanes for 3 years and go, we're going to fix them one of these days, but we're not going to do it just yet, and
Well, you have a duty to mitigate your damages.
That's right, and we did that. And we fixed the airplanes as quickly as we reasonably could, and there was all this interdealing back and forth with Mr. McBreen, who was their agent, and he lulled us into this, we're going to recommend payment, we're going to do this, don't worry about
But
it.
if the planes are damaged if a plane is damaged on day one, and you don't have an obligation to make a demand, but at 3 years you do, and you give 6 months to pay, when does the statute of limitations run under your argument?
I think there's an implied requirement that we make some kind of a demand and present, some kind of a presentment of what the damages are, because they don't know what to pay. They don't know what to pay.
As you make your demand at 3 years, and say, pay us in 6 months, does the statute run a year after your demand, 6 months after the date you told them pay them, or does the 4 years start from the 3 years, or does the 4 years start from 3 years and 6 months, or, I mean, what is your argument as to when the statute began to run?
The question is, how does Texas law look at this? And it's
Right.
answered in intermedics, and it says that the statute of limitation runs when there's an unequivocal refusal to comply with the terms of the contract. The contract required them to pay for the damage. When they decided they're not going to pay because they think they got a gotcha under the tort 2-year statute.
But if you have an obligation to make a demand, how would they ever know the amount to
I think
pay?
we have an implied duty to make a demand. We have to make a presentment so they'll know what to pay. Again, write you, here's a blank check, you guys fill it in for whatever you want. That's not reasonable. They had to be presented with information. They were, and Mr. Murray just got through telling you, there was this back and forth about, we're going to do this, and we'll pay that, don't worry about it, and that's what the intermedics was. They were lured into a false sense of security. Mr. McBreen said, I'm going to recommend payment. Why would we sue when we have an assurance that they're going to do exactly what they were contractually required to do? And only when they gave us an unequivocal, no, we think we got a gotcha, we think we got a tort claim, irrespective of the fact that there's this contract, we're going to style this as a tort, we got 2 years, we got a gotcha here, so we're not going to pay you anything, go away. That's when the breach occurred, and we filed all our actions within the statutory requirement for the 4-year statute for the breach of the contract. The breach being when it accrued, and when it accrued was when they made an unequivocal refusal to pay, and I got 18 seconds left.
What day did they make the unequivocal refusal?
Well, it was done when Mr. Murray's client, she just got through telling her name, decided, no, we're not going to pay anything. And that may have been on his
Do you have a
license.
date? Do you have a date?
August, I don't have a date. It was August 15th, I want to say, but I don't remember the year. It was within the 4 years.
All right, counsel, thank you both
Yes, sir.
so much.
Thank you, gentlemen.
All right,